Hey class, welcome to week 11. I hope everybody had a good spring break. I hope that you are all staying safe and healthy. And for those of you with essential jobs where you've actually got to do something other than telework, thank you so much for continuing to serve your communities in the face of this pandemic. This week we are going to discuss how we, the public, hold our government agencies accountable for harm that their actions cause. So we're going to discuss the concept of judicial review, including the authority of courts to hear cases, as well as concepts of standing and ripeness, and then the standards of review that courts use to examine agency actions. We're also going to talk about this idea of government liability, which implicates issues of sovereign immunity. Specifically, we're going to talk about the government's limited waiver of its sovereign immunity so that we, members of the public, can sue the government for harm that it causes. Finally, we're going to discuss the role of the courts in developing a body of environmental law, starting back in the 1960s, but mostly focused on today because we find ourselves in some uncharted territory. But first, I want to talk a bit about current events, specifically executive branch and other agency action in response to the coronavirus pandemic. In the past couple weeks, we've heard a lot about the Stafford Act and the Defense Production Act, so I want to talk about those in a little bit of depth. Now, we did discuss the Stafford Act back in week 7 when we talked about agency operations. We will discuss it again next week. So you know that the Stafford Act authorizes the president to establish a disaster preparedness program and assist states in preparing for, but also responding to disasters. Now, the COVID-19 pandemic is a global disaster, and it really does require global cooperation. But countries have to take care of their own citizens, and in part, that's what the Stafford Act authorizes the federal executive branch to do. So in response to the coronavirus pandemic, President Trump invoked the Stafford Act on March 13th, 2020, and he was relying on Section 501B. Now, that's the section number from the public law version, not from the U.S. Code. If you're looking for this in the U.S. Code, it's actually 42 U.S.C. Section 5191B. So that's the equivalent to Stafford Act Section 501B. Since issuing the emergency determination, Trump has also declared or approved state declarations of major disasters or emergencies all across the nation, starting with the state of New York on March 20th, 2020. So the president's declarations make federal funding available to state, tribal, and local governments, as well as certain nonprofits. And it makes this funding available for emergency protective measures, crisis counseling, things like that. The declarations also trigger FEMA assistance to local, state, tribal, and territorial governments, and FEMA has in turn required that these governments execute their emergency response plans. So FEMA assistance includes things like managing and reducing immediate threats to public health and safety, so that in this case would include disinfecting public facilities. FEMA assistance can include assisting with emergency medical care and temporary medical facilities, as well as any required sheltering for household pets. FEMA assists with communicating health and safety information to the public, and also with purchasing and distributing food, water, ice, medicine, and other consumable supplies, including personal protective equipment, which we'll call PPEs, and other types of equipment such as hazmat suits. While the federal government is now engaged in the COVID-19 response, many state and local governments began responding much earlier. So there is a lot of criticism that the federal government took too long to act and to trigger Stafford Act and other authorities. So states and local governments took this into their own hands. For example, Washington Post did an article on Bristow, Oklahoma, where the hospital there, its chief medical officer, happens to be an epidemiologist, also happens to be a veteran of Hurricane Katrina and the Oklahoma City bombing. So he saw what was happening in China back in January of 2020, and he organized a citizen response team in Bristow, basically to prepare the community for the coming virus. And by mid-February, That response team was in place, and the local school system had created a program to feed kids if the schools closed. That was necessary in Bristow because 25% of its residents live below the poverty rate. And so that means that a lot of those kids rely on free meals at school. We've also seen at local and state levels that the response to COVID-19, it does not need to be partisan. This pandemic, it is not a political issue. It is going to kill Democrats and Republicans and independents and people who don't care at all about politics in equal measure. So my home state of Maryland, very, very blue state, legislature is firmly controlled by Democrats, but we currently have a Republican governor, Larry Hogan, and he really sprung into action early. He was relying on state medical experts, and he's done a really admirable job, in my opinion, at leading the state and cooperating with his Democratic colleagues in order to protect all Marylanders. Now, in addition to the Stafford Act, President Trump has invoked the executive authorities granted by the Defense Production Act. This is interesting to me because as a government contracts attorney, I know a lot about the Defense Production Act, the DPA, but I don't tend to hear about it in the news very frequently, or from anybody else who doesn't actually work constantly with government contracts. So the DPA, it was enacted after the Korean War. It's a preparedness and response law that allows the federal government to obtain and distribute supplies for the national defense. So it was originally for military readiness, but it has been expanded and also applies to allow the feds to respond to national emergencies. So like I said, general public, we generally don't hear about the Defense Production Act, but government contractors are familiar with it because every government contract, or most government contracts, have terms about the Defense Production Act and rated orders. The Congressional Research Service, which is a rare legislative branch agency, found that FEMA relied on the DPA authorities pretty extensively during the 2017 hurricane season, and that was in order to prioritize contracts for food, bottled water, and things like the restoration of Puerto Rico's electrical grid. So the DPA allows for these rated orders where government contractors are told, you know, this is your highest priority contract, you've got to go ahead and fulfill this contract. So that's one of the main provisions of the DPA. It stimulates industrial production by compelling private companies to produce the supplies that are needed to respond to an emergency. And it compels private companies to do this by requiring that these companies, which are generally already government contractors, accept additional government contracts for the production of those supplies, and by requiring companies to prioritize those government contracts over any other work. The DPA also allocates resources. It lets the president decide where materials, services, supplies, and other facilities need to go. Who gets them, how many do they get, and when. And that's got to be done, of course, to promote the national defense or national security, and that would be in response to our current pandemic. The DPA also strengthens domestic capabilities by offering incentives to industry. It allows the president to provide appropriate incentives for companies to develop, maintain, modernize, restore, and expand production capabilities. So we're talking about domestic production of critical components, critical technology items, materials, and other resources that are essential for our national security and safety. And the DPA requires that the president take appropriate actions to assure that the nation has these critical components, critical technology, etc. They've got to be available from reliable resources, kind of on an as-needed basis to meet whatever emergency we're trying to respond to. The Defense Production Act also lets the president appoint experts to provide advice and consultation. So basically, the president gets to enlist university and industry experts. It also prohibits the hoarding of designated scarce resources, and it provides for judicial review of agency action. Now, some news sources have sort of implied that the Defense Production Act nationalizes companies, and that's not true. It does not nationalize companies. it does allow the federal government to assert some authority over business decisions, particularly as it relates to manufacturing of supplies. Now, it is not always necessary to invoke the Defense Production Act. So recently, companies like Ford and GE and 3M, they were working collaboratively to produce respirators, ventilators, and masks for the COVID-19 response, and that was without the president invoking DPA authority. However, invoking this authority early in a crisis can often be a really crucial step to protect the nation, and that's because companies can't pivot quickly from making one type of item to making another. So invoking the Defense Production Act early on, it does give companies some time to ramp up production before the crisis fully hits. Now, President Trump has invoked DPA authority in several different ways. So on March 18th, 2020, he issued an executive order on prioritizing and allocating health and medical resources to respond to the spread of COVID-19. Via this executive order, Trump delegated authority to the Secretary of Health and Human Services to go ahead and use the Defense Production Act to obtain essential medical supplies and equipment, and that would include ventilators and PPEs. Second, on March 23rd, Trump issued another executive order, this one on preventing the hoarding of health and medical resources. So again, this order delegated authority to HHS to implement restrictions on hoarding, track how supplies and resources are distributed throughout the nation, and the president did direct via this order the Secretary of HHS to consult with the FEMA administrator when carrying out these activities. Then third, on March 27th, Trump did invoke the DPA specifically to order General Motors, GM, to produce ventilators as requested by Health and Human Services. There's also been a lot of agency discretion. So in response to the pandemic, agencies have issued guidance about relaxing enforcement. So as we discussed earlier this semester, one type of agency action is enforcement of laws and regulations, and agencies generally have discretion when it comes to prioritizing these types of enforcement activities. So for instance, on March 26, 2020, the EPA announced a temporary policy designed to basically provide enforcement discretion. Basically, the EPA let regulated parties know that they're off the hook for non-compliance with certain environmental regulations, so long as the company can show that that non-compliance was the result of a pandemic. The EPA is not alone in relaxing regulatory requirements. Health and Human Services relaxed enforcement of certain HIPAA privacy requirements, basically to allow doctors and other health practitioners to quickly transition to telehealth or telepractice, providing therapy over Zoom or Google Hangouts or similar platform. NSF, the Department of Defense, Department of Energy, and other agencies have also relaxed requirements for their contractors and grantees, basically allowing regulated parties to focus on responding to the COVID-19 pandemic rather than worrying too much about getting in trouble for not complying with a whole host of more minor regulations. This does not allow regulated parties to engage in criminal activity, and again, they've got to prove that their non-compliance relates directly to the pandemic and also that they're going to come back into compliance quickly. Okay, now we are going to turn to our scheduled lecture topic. So let's talk about agency accountability, liability, and judicial review. So there are, as I've mentioned, 3 ways that agencies are accountable to the public. We've got public access laws like FOIA and the Government in the Sunshine Act. Then we've got judicial review, where courts actually take a look at regulations and agency actions. And then there's the legal and financial liability for harm caused. Now, liability can have a big impact on public administrators, because if you work for the government, you need to continually look for ways to perform your job more efficiently, effectively, and safely. Now, government employees can be sued if they cause harm while they are, acting in the course of their employment. However, for the most part, those of us who work for the federal government and state governments, we actually have personal immunity from suit. And that's because we want to make sure that government employees aren't paralyzed with fear of being sued. So usually if you get sued as an employee, your agency steps into your shoes and takes care of that for you. And then judicial review, as it applies to environmental law, the courts in the US have actually both helped and hindered the development of environmental law. And so we're going to look at some of those cases. So when a court hears a case, for instance, let's say police officers bust into your house without a warrant and they destroy your property, and it turns out they actually meant to be in your neighbor's house. Well, you can sue them, and the court will get to actually hear your claim, your lawsuit against the police, because of the doctrine of judicial review. So this is the doctrine that allows courts to review actions by the legislative and executive branches and determine whether those actions are constitutional. So this is the reason why courts can review federal statutes, federal regulations, and also acts and omissions of agencies. So judicial review really sets forth the authority of a court to hear the case. And this authority flows from common law, constitutions, and statutes, both at the federal and state levels. So the Constitution, the federal Constitution, gives the U.S. Supreme Court original jurisdiction over a handful of cases. And those are generally lawsuits between the states. So if Colorado sues Maryland, cases that affect ambassadors, and then cases that affect diplomats. So the Supreme Court's got original jurisdiction for that. And in its original jurisdiction, it acts as a trial court. For all other cases, the Supreme Court has appellate jurisdiction. So you can get to the Supreme Court in two different ways, via its original or its appellate jurisdiction. If the court has original jurisdiction, such as in lawsuits between the state would actually file directly with the Supreme Court, and the Supreme Court would act as the trial court. But for everything else, you would either have to file your case in a federal district court, the federal trial court, and appeal all the way up through the federal court system to the Supreme Court. You can also file in a state trial court and appeal all the way up through the state court system, and then appeal to the Supreme Court, assuming that there's some type of a federal or constitutional question involved. Now keep in mind, the Supreme Court does not have to hear cases on appeal. Its appellate jurisdiction is entirely within its control. It has complete discretion over the cases that it takes. And the Supreme Court is usually going to hear cases if there's what we call a circuit split. So when, let's say, the Court of Appeals for the Fourth Circuit has ruled one way and the Ninth Circuit has ruled the other way, and it's becoming difficult to understand what the law really requires, the Supreme Court would be much more likely to take a case in that instance. So the Supreme Court building itself is beautiful and well worth seeing if you happen to be in DC. It is not on the National Mall, so you have to go a little bit out of your way to find it, but once you do, you can also check out the Library of Congress, get really kind of up close and personal with the Capitol building. But in the Supreme Court, you can sit and listen to oral arguments if they're taking place that day. If you want to hear the whole argument, especially if it's on some type of a hot button case, then you need to get there early. It's sort of like, the most popular concert tickets in history. There are people who actually camp out in line for some of these Supreme Court cases. But the court also lets the public rotate through. So if you don't care about hearing, an entire oral argument, you can just kind of go in a small group, rotate in and listen for 5 or so minutes, and then rotate out. So the Supreme Court's geographic jurisdiction covers the entire United States and all of its possessions. And so that means that cases that originate in Puerto Rico or Guam can also make their way to the Supreme Court because people who live in Puerto Rico are Americans. At the Supreme Court, there are 9 justices. We never call them judges at this level. Like all members of the federal judiciary, Supreme Court justices are appointed by the president and confirmed by the Senate. Now, in addition to justices, there are approximately 450 support staff who work at the Supreme Court, and that includes 4 law clerks per justice. So at the court, cases are tried en banc, and what that means is that all 9 justices hear the case together as a group. This is a little bit different than the way that courts of appeals work. Usually, the Court of Appeals will sit in a 3-judge panel, and then it only sits en banc if, something is remanded or if they think that it's really a crucial case and everybody needs to be there. But in the Supreme Court, it's always going to be 9 justices. And each case results in usually a majority opinion, sometimes a plurality opinion. So a majority opinion is any time where at least 5 of the justices agree on the outcome and the analysis and reasoning that led to that outcome. A plurality opinion is one where no single opinion got the majority, so there weren't 5 justices, but one opinion received more support than any other opinion. And a lot of times in plurality opinions, the majority of justices actually agree on the outcome, but they differ in their analysis, how they got to that outcome. So that's the reasoning for a lot of plurality opinions. So why do we have judicial review at all? Well, we have it because of a Supreme Court case in 1803 called Marbury v. Madison. So this picture here is an inscription that's on the wall of the Supreme Court building, and it says, it is emphatically the province and duty of the judicial department to say what the law is. So this concept of judicial review had been around since the early 1600s. And at that time, English courts decided that they could nullify acts of Parliament. And those are statutes the same as laws passed by Congress. The concept of judicial review was lost in England later in the 1600s, but by that time, it had taken root in the American colonies, and it survived on this side of the Atlantic. And the concept of judicial review was very widely discussed in a very positive light at the Constitutional Convention. It's also discussed in the Federalist Papers. There's a lot of back and forth about the need for judicial review. So Marbury v. Madison was a really fascinating case at the time. All of the people involved were very well known. Like if this were happening today, Bravo would have a reality show about it. Because it was really, people were riveted by this case. So the key players, we've got John Adams. He was at the time the president of the U.S. He was a member of the Federalist Party. At the time, we had the 2-party system was the Federalists and then the Democratic Republicans. So at the time of Marbury v. Madison, Adams had been voted out. So he was a lame duck president. William Marbury, also a Federalist, was one of Adams' last-minute judicial appointees. Then we've got John Marshall, newly appointed as the Chief Justice of the Supreme Court. He is the first Chief Justice who really made an impact. So when you think about the history of the U.S. Supreme Court, it actually really starts with him. But in addition to being the new Chief Justice, John Marshall was also the acting Secretary of State for John Adams. Then we had the incoming president, Thomas Jefferson. TJ was a Democratic Republican. Now, you may be aware that Jefferson and Adams engaged in a lifelong debate, sometimes an intense rivalry. They actually died on the same day, which was the 50th anniversary of the signing of the Declaration of Independence. And they wrote to each other constantly. But at the time of Marbury v. Madison, they were not on the best of terms. They had had a falling out. Federalists and the Democratic Republicans basically disagreed with each other about everything, which is not terribly different than what we have today. And finally, there's Jefferson's Secretary of State, James Madison. Okay, so what happened? John Adams, who's a Federalist, lost his re-election to Thomas Jefferson, who's Democratic Republican. and at the same time, the Federalist-controlled Congress lost as well. So the incoming Congress was going to be controlled by the Democratic Republicans. So the Federalists were very unhappy with this situation, but they still had power during this lame duck session. And during that session, the Federalists passed the Judiciary Act of 1801. That modified an earlier Judiciary Act in a number of ways, including adding more federal judges and federal justices of the peace. So at the last minute, Adams appointed, and the Federalist-controlled Senate confirmed, 16 Federalist Circuit Court judges and another 42 justices of the peace. And these were called the Midnight Judges because they were appointed literally almost at midnight, right before the clock struck 12 and control of Congress was transferred from Federalists to the Democratic Republicans. So William Marbury was appointed as a Justice of the Peace in D.C. But in order for his appointment to take effect, the papers had to be delivered by the Secretary of State. So at the time, that was John Marshall, who had also just been appointed as Chief Justice of the Supreme Court. Adams had signed the appointment letter for Marbury, but Marshall hadn't been able to deliver it. He just ran out of time. And he assumed that the incoming Secretary of State, James Madison, would go ahead and deliver the appointments because they had technically been properly submitted and approved and were technically legally valid. So we've got an appointment that Marshall hasn't delivered to Marbury, but he thinks Madison's going to deliver it. Instead, Jefferson takes office and tells Madison not to deliver the appointment. So Marbury never gets his Justice of the Peace job. And he goes ahead and sues in the Supreme Court. And he says that this new Judiciary Act actually gives the Supreme Court some original jurisdiction, and he can go and file directly with the Supreme Court. So Marshall says, okay, yes, Marbury has the right to the appointment, but the Judiciary Act of 1801 actually conflicts with the Constitution. And the Supreme Court doesn't have the power to tell the Secretary of State what to do in this case. So the end result was that Marbury got screwed out of his job, but the Supreme Court got the final say over all laws passed by Congress. The Supreme Court in Marbury v. Madison established that it's got the power to interpret the Constitution and statutes and really hold Congress and the executive branch accountable. So the questions from Marbury v. Madison, it said, the first question is, does Article 3 of the Constitution, which sets up the judiciary branch, create a floor for original jurisdiction, or does it create an exhaustive list of original jurisdiction that Congress can't modify? So in other words, can Congress add to the types of cases that can be filed directly with the Supreme Court? And the court said no. Congress cannot change the Supreme Court's original jurisdiction because it is set forth in the Constitution. The Constitution has the final word on it. And Marbury v. Madison, the opinion, also basically said, look, if there's a conflict between Congress and the Constitution's going to win. The Constitution trumps laws that are passed by Congress. And more importantly, for judicial history, Marbury v. Madison says that it's the Supreme Court that gets to decide the conflicts between Congress and the Constitution. So Marbury never got his job, but the Supreme Court got the power to act as this major check on the power of Congress. So the Constitution provides for judicial review, but judicial review can also come to us through statutes. Congress can pass a law, and in that law specifically provide authority for the courts to review that law. And we call this statutory review. And if it exists, the courts have to strictly adhere to it, unless, of course, there is a constitutional issue. So Congress can limit the ability of courts to review statutes. This is generally, when it's based on time, called a statute of limitations. It's a time limit. You might have 60 or 90 days from the date that you knew about a problem, you know the problem exists, you've got 60 to 90 days to file your lawsuit. And if you miss that filing deadline, the court loses its jurisdiction and can no longer hear the case. Congress can also limit judicial review based on the location of the suit. So for instance, if you want to sue the IRS, you actually have to do that in Washington, D.C. or in a specialized tax court. Congress can also place some limits on the manner in which you raise your suit. So you might have to jump through some hoops before you can get into court. Congress is not supposed to be able to limit judicial review of constitutional issues. That doesn't mean that it doesn't attempt to, just that those attempts are usually unsuccessful. Now, if the statute itself does not provide for specific review, and it's not necessarily a constitutional issue, we look to common law doctrines. Common law actually dates as far back as William the Conqueror, so we're going way back to 1066. And he combined Saxon, Danish, and Norwegian legal precedents, and he made them common to his whole kingdom. So that's why we actually call it common law. And there are a few different doctrines to be aware of. So one is certiorari. You can call it cert. If somebody wants to appeal to the Supreme Court, and the Supreme Court doesn't want to hear the case, you'll typically see a statement that simply reads cert denied. Another common law option is an injunction, which is a court order that either commands or prohibits certain actions. And these are pretty common today. If your neighbor keeps, parking his car on your lawn, you can get an injunction that says, stop parking your car on my lawn. There's also habeas corpus, which is a writ, and writ is just an old-fashioned term for issuance of paper. It's a writ to determine whether or not the government has jurisdiction and authority to detain someone. We tend to think of habeas corpus as a criminal law proceeding because it's usually prisoners who file habeas petitions, but it's really a civil proceeding, and it literally means show me the body. And the government at that point has to bring the detained person physically in front of the court, and the court determines whether the government has the authority to continue detaining the person or if that person has to be released. There is also a writ of mandamus, which higher courts issue to lower courts or to government officials to require that they take a specific action, do a specific thing. And it is actually the writ of mandamus that helps create the basis of judicial review in the United States. So it predates Marbury v. Madison. Marbury v. Madison was relying on the existence of mandamus. So jurisdiction is one portion of a court's authority to hear a particular case. And it's often based on the characteristics of the case. So subject matter, is this going to be a criminal case, a civil case, or some type of specialized case? Jurisdiction over the parties. So who are the parties? Federal government, state government, individuals, corporations. Actually, corporations are considered persons in terms of lawsuits. And then there's jurisdiction based on geography, not just the location of the parties, but the event at issue. So if you get into a car accident in downtown Denver and you live in Boulder and the person who hits you lives in Colorado Springs, you probably want the case tried in Denver because that's where the event took place. So within court jurisdiction, it can be vertical and horizontal. So vertical is the hierarchical jurisdiction that we have been talking about. Cases start at the lower courts and they get appealed all the way up. So in vertical jurisdiction, the cases bubble up from the bottom to the top, and then the policy issues actually flow from the top down. So the Supreme Court sets policy with its decisions that then have to be followed by the courts of appeals and district courts. Horizontal jurisdiction is case type, and usually it exists to manage caseloads within a court system. So you might have trial courts that are separated into different courts depending on the amount of the dispute. Felonies versus misdemeanors will be held in different criminal courts. Small claims court is for claims under 7,500. So it's the horizontal jurisdiction that helps courts balance the workload. There are also some specialized courts like family court, tax court, and drug courts, and they exist to help the trial courts manage their workload by appointing judges who are experts in a very specialized field of law. Now, federal courts can only hear cases that federal law puts within their jurisdiction. So if a federal court can't hear a case, that's when the state courts hear it. We have a handful of types of federal jurisdiction. There is federal question jurisdiction. So these are both civil and criminal cases that require the application of the U.S. Constitution, federal laws, and or international treaties. If the federal government is a party to the case, then the federal courts have jurisdiction. And there's also diversity jurisdiction, or diversity of citizenship jurisdiction. And that's for cases that are worth more than $75,000, and the parties are citizens of different states, or one party is a foreigner. And the reason for diversity jurisdiction is that the framers of the Constitution wanted federal courts to have jurisdiction in cases where there are citizens of two different states, because they didn't want state courts to be biased. So for instance, if I'm a Maryland resident and I get injured at a ski resort in Colorado, I can sue the ski resort in Maryland, but then that can be removed to federal court. And the reason for that is because the framers were concerned that Maryland courts would be biased in favor of their own residents. So the Maryland court's going to rule in my favor because I'm a Maryland resident. So instead, the framers thought, let's have these cases of, cases that involve parties from different states, let's have them resolved in federal court, because there won't be that desire to help a citizen of your own state. So jurisdiction deals with the court's authority to hear a case, and it can have these geographical implications. Venue, on the other hand, is strictly geographical. It is all about location. It usually relates to where the parties live and where the events of a case took place. And parties can waive issues of venue. As a Colorado resident, you can consent to being sued in Maryland, but you cannot waive jurisdiction. If the Maryland court does not have jurisdiction, you cannot say, that's okay, go ahead and take the case anyway. And venue, we typically hear about it in criminal cases because defendants will ask for a change of venue if they believe that local prejudices will make it impossible for them to receive a fair trial. These requests for change of venue are rarely granted in most cases. They are granted in high-profile cases a lot of times, which is why the O.J. Simpson case back in the 90s had a change of venue. So did the Aurora movie theater shooting case, because the feeling was that the local community was going to be too prejudiced against the defendant to get a fair trial. So as I mentioned earlier, Congress can impose restrictions on federal court jurisdiction. Congress often does this in the form of statutes of limitation, which cut off a court's authority to hear a case once a certain amount of time has elapsed. Congress can also define the jurisdiction of the lower federal courts in a way that eliminates their ability to hear certain cases. So for example, there are several statutes that limit the remedies available to prison inmates. So for instance, if prison inmates are limited in the number of habeas corpus petitions that they file, courts are effectively limited in their ability to hear those cases. Congress, like I said, is not supposed to be able to limit judicial review of constitutional questions. That's never been actually fought out in a court, but the Supreme Court has strongly implied that it would not stand for such a limit. But Congress can limit review in cases that do not involve constitutional issues, or it can preclude review entirely so that you can't get to court. If it does either of those, it does have to comply with the Due Process Clause. You've got to have some reasonable chance of pursuing your claim in court. That is why you will never see a statute of limitations that gives you like 2 days, because that would violate due process. If Congress precludes judicial review altogether, it has to do so by showing clear and convincing evidence in the language of the statute. And that's what I've got here. This Smallpox Emergency Personnel Protection Act, this is an example of clear and convincing evidence in a statute that precludes judicial review. Because you'll see there that no court shall have subject matter jurisdiction to review any action by the Secretary under this section. And when Congress passed the Smallpox Emergency Personnel Protection Act, so it was very clearly saying, courts, you don't get to review what the Secretary of Health and Human Services does as it relates to smallpox. So if the Secretary makes a call to protect government personnel from smallpox, and you as a citizen disagree with that, that's too bad. Congress provided clear and convincing evidence that they don't want people to be able to challenge the Secretary's actions. And in this case, there's an actual reason to preclude review. Congress didn't just willy-nilly decide that Americans can't challenge Health and Human Services, but this is a matter of public health and safety, and Congress thought that it was best for the agency to be able to take actions needed to contain outbreaks of smallpox without worrying about being sued. Now, there are plenty of times when Congress tries to strip a court of jurisdiction over controversial social issues, and that almost always fails. So for instance, there was a bill in 2005 that would have prohibited the U.S. Supreme Court from hearing cases involving a government official's acknowledgement of God as the supreme source of U.S. law. Clearly, such an acknowledgement would violate the First Amendment, which protects religion from government and government from religion, and it applies to non-believers as well as believers of all religions. So that was not going to fly, and often these bills do not even get out of Congress because Congress knows that it's going to get struck down. So federal courts continue to hear cases that involve religious liberties, civil rights, and general attempts by public officials to impose their personal views on everyone else. Okay, so now we've talked a little bit about the basics of jurisdiction and judicial review. Let's talk about standing and ripeness. In order to get into court, you have to have standing, and your case needs to be ripe. These are two sides of the same coin. Standing is the question of, do you, the person suing, have a right to be heard in court? Ripeness is a question of, does the court have a right at this point in time to hear your case? So your case has to be ripe enough. The defendant has to have gone so far in his or her detrimental behavior that a court can now step in and hear the case. So standing is the requirement that the plaintiff or plaintiffs have a personal interest in an actual case or controversy. Typically, so the plaintiff's got to have something to lose, got to have some type of skin in the game. And that's because the Constitution, in Article 3, Section 2, limits the federal courts to hearing cases or controversies. And this requires an actual dispute, not something theoretical, and not a future dispute. There is an exception to this. There are statutes that grant automatic standing where you as a plaintiff do not have to be personally affected by the case. And you'll see in the Clean Air Act here, I've got the section that allows citizens to sue polluters for Clean Air Act violations and to sue the EPA for its failure to enforce the Clean Air Act. So statutes can have a major impact on standing. If the statute is silent, then we fall back to common law principles of standing. If a statute expressly limits review, the statute applies. If a statute expressly provides for review in excess of what the common law provides, that statute applies. So the notion of standing has evolved. Traditionally, the plaintiff had to prove that the defendant violated the plaintiff's legally protected interest or right. So simply the fact that the plaintiff suffered a financial or a physical injury was actually not enough to establish standing. You had to prove that the defendant violated your right. And this traditional test worked well enough back in the day when the US was a very rural agrarian society, but it proved unworkable as the country industrialized and grew to what it is today. Because under the traditional test, the courts had to address the merits of the case in order to even determine if standing existed. So the courts might litigate the entire case only to find out the plaintiff didn't have standing, thus no right to be heard in court, and thus that was a huge waste of time for everybody involved. So the growth of government, society, and the ever-increasing court workload required a new system that would provide a more flexible approach. And so now we have a modern test of standing that has 3 prongs: injury, causation, and redressability. So injury has to be an actual injury. Typically, in civil suits, it is an economic injury, the plaintiff has lost money, or a personal injury, the plaintiff is physically or emotionally injured. Then there is causation. And that means that the plaintiff's injury must have been caused by the defendant. Or in our case, looking at administrative law where government agencies are involved, the plaintiff has to be injured by agency action. Whatever the agency did, issuing a regulation, inspecting the plaintiff's business premises, must have somehow injured the plaintiff. And then the injury must be redressable, which means that if the court finds in favor of the plaintiff, the court has to have some ability to fix the plaintiff's injury. And where it's an economic injury, that's pretty easy. If some agency action was unconstitutional and you lost $500,000 because of it, the court will find that the agency owes you $500,000. For non-economic injuries, it can be more challenging to determine how to appropriately compensate the plaintiff for his or her loss. Now, environmental cases often involve non-economic injuries, and they're often also class action suits. So times when groups like the Sierra Club sue the government because at least one member of their organization has suffered harm. So usually this is not financial. It might be something like loss of use of public lands. This happened in Colorado back when the Roan Plateau was opened for drilling and fracking. Coloradoans who liked hiking and snowshoeing and camping on the Roan Plateau sued, alleging that they would be injured by their ability, the loss of their ability to go and enjoy the natural beauty of the Roan Plateau. So there are environmental law cases that provide standing to citizens who want to protect the environment, so long as the citizen can show some type of harm to their own interest. And I've got here Scenic Hudson Preservation Conference versus the Federal Power Commission. And this case is now hailed as really the birth of environmental law as a separate branch of legal studies in the United States. This case was part of a 17-year-long dispute that started back in the early 1960s when Consolidated Edison announced that it was going to build this huge hydroelectric power plant on Storm King Mountain, and it was going to cost like over $200 million, and Con Edison was also going to buy 300 acres of the Black Rock Forest. Well, in response to that, a bunch of citizens in the area, in the Hudson Valley, formed the Scenic Hudson Preservation Conference to provide kind of a unified voice in opposition to the project. But regardless, despite all this opposition, the federal government granted Con Ed the right to proceed. And that decision was immediately appealed, and it actually got up to the Second Circuit Court of Appeals. And then it got all the way up to the Supreme Court, which for the first time held that an aesthetic harm actually suffices as a type of injury in fact. And so an aesthetic harm can establish standing. So in this case, The Storm King project was going to be located in an area of what the court called unique beauty and major historical significance. So these are the Highlands and the Gorge of the Hudson. It's really a beautiful river scenery. And so the court decided, yeah, this group of citizens, the Scenic Hudson Preservation Conference, they've got standing because they would lose aesthetic beauty if this power plant was built. And so this established a really important legal precedence for similar groups to be able to take legal action to really protect the environment and the public interest. One of the next big cases about environmental standing was Lujan versus Defenders of Wildlife in 1992. In this situation, the Fish and Wildlife Service issued a regulation stating that the Endangered Species Act applied to agency actions, U.S. agency actions in foreign nations. And this got a lot of pushback because the U.S. was funding a number of projects abroad that would be halted because of this. So Fish and Wildlife Service changed its position and said, oh, we were just kidding. The Endangered Species Act only applies within the United States. So a group of environmentalists challenged Fish and Wildlife because they believed that, if the U.S. government is the one harming endangered species, regardless of where in the world, then the Endangered Species Act should apply. So what the Defenders of Wildlife said is that, look, right now, none of our members are viewing those endangered species, but sometime in the future, they might want to see an animal that no longer exists because the U.S. government destroyed its habitat. Well, in this case, the court said that's a future injury, and that is, at this point, conjecture. In this case, the court probably would have found standing if even a single member of the Defenders of Wildlife had booked a plane ticket to go and view one of those endangered species. So this case stands for the principle that the possibility of future injury is not enough. You've got to have a present injury and a present case or controversy. In a different case that involved the Fish and Wildlife Service, Bennett v. Speer, the court held that the plaintiffs did have standing because they were suffering a present injury. And in that case, Fish and Wildlife Service had issued a biological opinion that harmed the plaintiffs' economic interests in the lake waters, so fishing, boating, all of that. And in that case, the Supreme Court said, yeah, they are suffering from a present harm, and it's traceable to this opinion that was issued by Fish and Wildlife Service, and we, the court, can, there's redressability because a favorable judicial ruling will help the plaintiffs. So these cases really let us know that, yes, you can have standing based on aesthetic harm or environmental harm, but there's got to be some type of present injury, even if it's minor. Like I said, in the Defenders of Wildlife case, even if one member of that group had a plane ticket to go and view one of these endangered species, then they would have found standing. There are some specific applications of the standing doctrine that apply in administrative law. Well, they apply everywhere, but they tend to come up in administrative law because we're focusing on federal agencies. So these include standing for American citizens and taxpayers, standing in whistleblower cases, and then standing for business competitors, consumers, and states. So for a while, American citizens would sue the government over laws that they didn't like. And eventually the courts decided that just being American in and of itself doesn't give you the right to challenge public expenditures. If you don't like how the government's spending money, you're not alone. About half of America doesn't like what the government's doing at any given time. But without some added injury, just being a citizen doesn't give you standing to sue in court. Same for taxes. Just because we pay taxes, that does not give us the right to challenge government spending. Now, there are exceptions for constitutional issues. So for instance, if you think that the federal government is spending money in violation of the First Amendment's Establishment Clause, you do have standing to sue. There's citizen standing that can be authorized by statute, and this includes what we call qui tam and whistleblower cases. And so Congress can authorize these, and they have. For instance, we've got the Federal False Claims Act that authorizes whistleblowers, qui tam relators is the technical term. And in these cases, a private citizen brings suit on behalf of the government, not against the government. And in these cases, the government can intervene and kind of take over from the private citizen who brought the suit. If they decline, the individual can continue to prosecute on behalf of the government, almost like they were a private attorney general. And the qui tam relator, the person who brought the case, is awarded somewhere between 15 and 30% of any recovered damages if the government steps in and takes over. They get 100% if the government declines to prosecute, and the qui tam relator actually succeeds. This was very recently in the news because Duke University just settled a massive qui tam case. Duke agreed to pay the federal government $112 million for submitting falsified grant proposals. And in that case, the whistleblower brought a qui tam suit, and he's going to get about $33 million of that settlement. Competitors can have standing if there's going to be agency action that affects an entire industry, then usually numerous competitors have standing. Don't confuse membership organizations with competitors. Membership organizations do not compete because they're not engaged in business, but members of those organizations might be competitors. Consumers have standing, and that's because if an agency action isn't challenged by regulated parties or their competitors, it's possible that individual consumers can go unprotected. So consumer suits are usually class actions. They usually have standing based on either pricing or some type of reduction of quality. States also have standing. They've got certain rights as sovereign governments. States can be injured by the actions or inactions of the federal government or other state governments, and so states have standing to sue both the federal government as well as their sister states. So now that we've talked about standing, let's move on to another crucial consideration, and this is the timing of judicial review. So the Administrative Procedure Act provides for judicial review of final agency actions, and that requires both that the plaintiff exhausted her administrative remedies and the plaintiff's case is ripe for a court to hear. So exhaustion of administrative remedies just means that you, as the harmed individual, have to pursue and complete everything at the agency level before you can get judicial review. And this is a doctrine that's required because it's not efficient to have a court review an agency proceeding that is still ongoing. Also because agencies are better at finding facts that relate to their regulatory area, so courts want the agencies to have a first crack at this. So in order to exhaust your administrative remedies, you need to review the statutes, regulations, industry practices, and figure out which hoops you need to jump through to get to court. So you've got to, file your claim by an agency deadline, submit your claim to the proper agency officials in the proper order, etc. There are exceptions to this, so you don't always have to exhaust your administrative remedies. And the exceptions are if the agency is unreasonable, so it unreasonably delays holding a hearing or it unreasonably delays issuing a decision. Constitutional challenges to a law that an agency is enforcing. Agencies don't have the authority to declare statutes unconstitutional, so there's really no point in exhausting your administrative remedies if the agency can't do anything and you've got to go to court anyway. And then there is ripeness. Like I said, courts have jurisdiction over actual cases or controversies, not just potential disputes. So generally, if a regulation is pending, but it is not yet being enforced, so for instance, the final rule was published in the Federal Register, but 30 days have not elapsed, then there is no case or controversy because the issue is not yet ripe. Now, at common law, that left the party with only two choices if there was a questionable regulation. And that was either comply with the regulation, which usually costs money, and then seek judicial review, or ignore the regulation, suffer the penalty for non-compliance, that also costs a lot of money, and then seek judicial review. Now we have the concept of pre-enforcement review, and that's possible if a pending regulation could cause substantial harm. So this comes up a lot in environmental cases. It also comes up in FDA cases. The main case on this is called Abbott Laboratories v. Gardner, and that was about an FDA regulation that required prescription drugs generic name to be on all labels and all related printing materials. So if you've never worked or don't know anybody who's ever worked for a drug company or medical device company, FDA labeling requirements are really expensive. They cost a lot of money. In the Abbott Labs case, the FDA said, Abbott Labs can't sue because we, the FDA, are not yet enforcing this regulation. And the court disagreed and said, no, because you're going to start enforcing this regulation any day now, and it's a substantial hardship to Abbott Labs to deny the pre-enforcement challenge. They would basically have to spend all of this money relabeling everything, then challenge it, and then if they won, they'd have to spend all this money relabeling again. So courts review 3 issues to determine ripeness. Are the issues fit for review? So legal issues are more suitable for immediate review, like this pre-enforcement review, than factual issues. Courts ask if you've exhausted your administrative remedies. The more remedies exhausted, the greater the likelihood that a court is going to find that your case is ripe for judicial review. And then they ask if there will be significant harm if pre-enforcement review is not available. So the greater the harm, the more likely it is that a court is going to allow pre-enforcement review. And you can think of pre-enforcement review as your case is almost ripe and we'll consider that good enough. Judicial review also involves a scope of review, and a scope of a court's review just refers to the issues a court is going to examine. And these tend to break down into questions of fact, questions of law, or mixed questions of fact and law. And scope matters because it can determine the standard of review a court's going to use, and we're going to discuss that in a minute. So the Administrative Procedure Act specifically provides for judicial review of agency actions, and that means that courts can oversee agency actions and they can compel action if an agency has unreasonably delayed or unlawfully failed to act. Courts can also issue injunctions to stop an agency from acting unlawfully. So if it's a question of law, you answer it by applying relevant legal principles to the case at hand. The interpretation of those legal principles is going to apply broadly to all cases. So for instance, does the Clean Air Act prohibit the use of a certain chemical in factories? That's a question of law because every factory, the legal interpretation will be the same. A question of fact is answered by referring to the relevant facts and the evidence that is presented. And there's no broader application to other cases. So a question of fact would be, did this particular company use this particular chemical in its factory? So you've got your question of law, does the law prohibit the use of a chemical? And the question of fact, was that chemical used anyway? So in criminal and civil law, the judge determines the questions of law, the jury determines questions of fact. But in administrative law, including a lot of cases that involve the EPA or the USDA or any of their sub-agencies, the court determines both. And it uses 3 standards of review. So there is the de novo standard of review, Courts use this to review questions of law, really only questions of law. And in this case, the court does not give any deference to the agency's legal findings. So the court can instead order an entirely new hearing where evidence and testimony is presented all over again. That's called pure de novo. Or it can review the record of the agency's hearing and rule based on evidence from that record. We just call that record de novo. Substantial evidence review, that is used to review formal agency action, so formal rulemaking and formal adjudication. And in these cases, the court is going to apply a reasonably prudent person doctrine. So substantial evidence exists where a reasonably prudent person, under similar circumstances, could reach the same decision that the agency reached. So was the agency acting reasonably? And in these cases, for substantial evidence review, the court doesn't substitute its own judgment, and it does use the administrative record of the agency hearing, and it can actually remand the case to the agency for further hearing if that record is lacking. Third is review for an agency's arbitrary or capricious action. And this is used to review all agency informal actions. So if you think about it, this is really the default standard because most agency action is informal. So this, in arbitrary and capricious review, the court is going to assume that the agency's decision is valid as long as it's rational. So there's a lot of deference given. But an agency's decision will be found to be arbitrary and capricious if the agency relies on factors that Congress had not intended it to rely on, if the agency totally fails to consider some important aspect of the problem, if the agency decision is simply counter to the evidence, or if the agency's decision is so implausible that it can't be explained as a difference of opinion or, some different experts disagreeing with each other. It's just way too implausible. And so courts will find that the agency has been arbitrary and capricious. Now, these are different from the standards of review that we discussed for constitutional questions. For constitutional questions, courts are using rational basis, intermediate scrutiny, and strict scrutiny. What I'm talking about standards of review here are related to deference to the agency and whether or not the agency action was formal or informal. So there are some common law doctrines that also limit judicial review, and these are primarily aimed at, the interests of fairness. So there's one that we call res judicata. In English, that is claim preclusion. Basically stops a party from relitigating a final judgment. So it's a lot like double jeopardy. There is collateral estoppel, that is issue preclusion. It's basically like claim preclusion, except that it's about a specific issue rather than the final judgment. There's equitable estoppel, also called promissory estoppel. That prevents a party from unfairly raising a claim. So if you make a promise to somebody and you intend, or a reasonable person would expect, that your promise is going to induce the other party to rely on you, and the other party does rely on your promise, and the promise is not enforced, then the party that relied on it is going to be harmed. So you, as the promisor, can't say, oh, well, it was a non-binding promise, because that is not fair. Then there is the common law doctrine of laches, which comes to us from French. And basically that says that, if you really unreasonably delay in raising a claim, we're not going to review it. You've got to be timely. You've got to raise issues in a timely manner. Now, that doesn't mean necessarily that you've got to raise issues the moment that you're hurt or suffer some type of other injury. You've got to raise your issue as soon as you know what actually caused your injury. So while the concept of judicial review is basically how courts have the authority to hear your case. Part of it is also about assessing liability. So individuals and organizations can be liable for their actions in three main ways. The government can go after them criminally, the government can go after them administratively, or they can be sued civilly, by another private party. So liability means that a party is legally responsible for its actions. Usually that is a financial responsibility. Often, or usually this is related to a breach of some duty, which we'll talk about momentarily, but there are other forms of liability. Liability is usually resolved by the court awarding monetary damages and or an injunction. So either requiring the defendant to do something or prohibiting the defendant from doing something. The government also has to take liability into consideration because government services, especially those that are critical to public health, welfare, and safety, so emergency response, law enforcement, environmental regulations, those often involve significant risk. And making the government pay for injuries that it, generally through its employees, causes, that's a tool for controlling agency discretion and preventing abuse. Because without government liability, individuals who are injured by government action would basically have to cover the consequences of that themselves. They wouldn't be compensated. Now, government liability is limited by legal doctrines, and we will talk about that. So, liability, when we talk about liability in legal terms, we are usually talking about tort law. And this is the body of law that deals with civil wrongs, so not criminal wrongs, and wrongs that do not arise out of a contract. So basically, any type of lawsuit that's not criminal and it's not contractual. Tort law is intended to deter people from harming others and to compensate people who are injured. And it defines what constitutes an injury and the circumstances under which one person is liable for another person's injury. And the word tort here is spelled differently than the delicious dessert, that is tort with an E at the end. Ours has no E. It comes from Middle English, which then itself comes from Latin, and it's the Latin word tortum, which means injustice or wrong. So keep in mind that for torts, these are usually cases between private individuals and entities. I am going to be speaking mostly about tort cases that involve the government, but the vast majority of tort cases are private. In state courts, and these figures are from a couple of years ago, but about 7% of civil suits in state courts are tort cases. Of those, almost half, 40% of them, relate to car accidents. So just general injuries from accidents. Of the 7% of civil suits that are tort cases, 85% of them settle before trial. So only 15% go to trial. The ones that go to trial, 0.2, so less than 1% of these end in judgments of over $500,000 for the plaintiff. The vast majority of judgments, 75%, are for less than $5,500. Additionally, only 3% of plaintiffs who win their tort case get an award of punitive damages. So there's a lot of discussion of tort reform, which for me as an attorney, I tend to think of as companies trying to keep people out of the courthouse, which I tend to find unfair. If we're injured, we should have some ability to go to court. But tort filings have actually decreased over the past 20 years. Now, tort cases against the government are especially prevalent for law enforcement agencies. And obviously, in the news over the past few years, there have been so many instances of Black or brown people who have been killed by the police when they haven't been doing anything wrong. Those then lead to tort suits. But again, only 6% of these judgments go in the plaintiff's favor. So a tort suit against the government you've got a very slim chance of winning. But if you win, you tend to win big. So for fiscal year 2013, New York incurred $732 million in legal costs, and most of these were from claims of police abuse, negligence, and hiring discrimination. All of those are torts. Across the US, there's an estimated cost of $3.6 billion per year in verdicts against police forces, and that does not include the hundreds of millions of dollars in settlements, so tort cases that settle before they actually get in front of a judge and jury. So torts can be negligent or intentional. The vast majority of them are negligent. If you think about a car accident, somebody runs a red light and hits you and you're injured, they probably weren't intentionally trying to injure you, they were just being negligent. So negligent torts, the defendant is not using sufficient levels of care in performing a duty owed to the plaintiff, and the plaintiff is injured. So that requires that there be a duty of care, the defendant breached that duty, and the injury that the plaintiff suffered results from that breach. An intentional tort, the defendant is acting with a specific intent to perform a wrongful act. You're walking down the street, and suddenly the police decide to arrest you because they don't like that you're wearing a green hoodie. And so they handcuff you and they sit you on the sidewalk for 5 hours. Well, that might be an intentional tort of false imprisonment because there was the intent to commit a wrongful act. Torts can also involve other types of liability, particularly strict liability and vicarious liability, which is also called respondeat superior. So in vicarious liability, that generally means that an employer is responsible for the actions of employees where those actions are performed in the course of employment. There's what we call a frolic and detour aspect to vicarious liability. So if the employee takes a minor detour, the employer is still liable. So for instance, you work for the government, you are driving from a meeting back to your office and you stop at McDonald's, that's a minor detour. If you get into a car accident, your employer might be liable. If you are on a frolic, you're acting completely apart from your job duties and the employer is no longer liable. So rather than head back to your office from the meeting, you decide to go take a trip into the mountains. Now you're off on a frolic, and you'll be personally responsible if you injure somebody. There's also strict liability, where the defendant is liable for injuries regardless of the precautions taken. This comes up a lot in extremely hazardous industries like nuclear power. It also comes up if you, say, want to own some tigers and lions. It doesn't matter that you've got them triple caged and you've got an electric fence around your property. If they get out or anybody gets in and is injured, you're going to be liable regardless of all those precautions that you took, because these are wild animals and you shouldn't be keeping them on your property, so you are strictly liable. So intentional torts, you actually know a lot about these already because they really mirror criminal law. Now, in terms of the actors, the tortfeasor is the defendant. I'm probably just going to call them the defendant, but tortfeasor means you're the one who committed a tort. And then the plaintiff is both a victim and a prosecutor. So intentional torts a lot of times mirror criminal law, assault, battery, false imprisonment, trespass to land, which is what we think of as trespassing, trespass to chattels, which is basically just messing with your personal property without permission. Conversion is theft, intentional infliction of emotional distress, and then libel and slander. And libel is written, slander is spoken. So you know the difference between the two because the S's. Slander is spoken. There is also a common law tort of public nuisance that can be intentional or negligent. This was and continues to be very important in environmental cases, even though common law torts including the one of public nuisance, can be displaced by statutes. Here are just some examples of negligent torts. Car accidents, slip and falls, if you negligently hire somebody, if you are negligent in your supervision of somebody, if you don't train them properly, or if you fail to discipline or you fail to investigate. These are all negligent torts, and they do come up in both the public and private sector. So there are these three elements for negligent torts. Duty of care owed to the plaintiff by the defendant. That's going to be determined by what we call the reasonable person standard. Would a reasonable person do the same thing under similar circumstances? And the gist of it is that a reasonable person is going to take precaution where the burden of taking that precaution is low and the likelihood of injury is high. If you've got an in-ground pool, you're probably going to have it in your backyard, and you're going to have it behind a fence. You're not going to have it in your front yard across the street from an elementary school, because if you've got it in your front yard across the street from an elementary school not fenced in, there's definitely a possibility that children are going to drown in your pool. So the burden of putting it in your backyard and putting a fence up is pretty low when the likelihood of injury can be very high. So when you think about the duty of care, you have to consider the cost of taking those precautions, the likelihood of harm, and the seriousness of harm that might be caused. Then there has to be a breach of that duty, so the defendant's conduct violates that duty of care, and then the plaintiff is injured, and that injury is related to the defendant's breach of duty. So the duty of care is a legal obligation that all of us act reasonably when we're performing any action or deciding not to take an action that could foreseeably harm other people. So it's the foreseeability of harm that's important. Like I said, you put an in-ground pool in your front yard, no fence, there's an elementary school across the street. Yeah, it's pretty foreseeable that some kid might come and try to take a dip in your pool and get badly hurt or killed. These duties of care, there are multi-factor tests to determine them, and they vary by jurisdiction. But basically, it's that foreseeability of harm, how closely connected is the defendant's conduct and the plaintiff's injury. Is there any moral blame attached to the defendant's conduct? States will also look at the possibility of preventing future harm, courts and states. And federal government looks at, the way to prevent future harm, deter others from acting negligently. Consequence to a community of imposing a duty of care. Can you get insurance to cover your risk? Was the defendant actually trying to be useful or helpful? And then are there alternative ways that the defendant could have acted? All of this can be impacted by industry or professional standards, including manufacturing standards and medical care standards. So here are some examples of duties of care. If you invite somebody onto your property, you have a duty not to harm them. You've got a duty owed to trespassers, both known and unknown. So if you've got a cabin out in the woods somewhere and you've decided to lay bear traps all around the perimeter, you need to put up a sign warning people about that. There are duties owed by manufacturers to consumers about, foreseeable use of products by the end user. In business and management, there is a fiduciary duty, and that is owed to your business partners, to your shareholders, and to your customers. This also is owed if you are high up in the government and you're involved in finances. You have a fiduciary duty to the government and the public. Basically, this means that you've got to, be reasonable and prudent in your supervisory functions and making decisions. There is a business judgment rule that assumes that you're carrying out your functions in good faith. If you are a professional rescuer, there is a duty to rescue. So if you're a firefighter and somebody's trapped out of a window screaming for help, you've got a duty to rescue when you are, currently on duty and you're acting as a firefighter. There is no general duty owed to rescue somebody if you are not a professional rescuer. Now, there is a duty if you're the one that creates a hazardous situation that injures somebody, then yes, you should try to rescue them. Spouses have a duty to rescue each other. Employers have a duty to rescue their employees. Common carriers, so planes, trains, they've got a duty to rescue passengers. If you attempt a rescue, you've got to use reasonable care. So then you've got the requirements of breach and injury. So the defendant has to have breached a duty, one of those duties of care, for instance, and as a result, the plaintiff has to suffer an actual injury. Now, the injury is construed broadly. It can be physical, it can be financial, it can be injury to property, or it can be a more intangible injury. For instance, your privacy was violated by a slanderous statement that somebody is making. You have faced emotional distress, something like that, something intangible. You can still have this injury. And then the injury's got to be related to the defendant's breach of duty. So that's easy when it's what we call an injury in fact. The injury would not have occurred if the defendant hadn't engaged in that wrongful act. It can also be what we call proximate cause. So it might not be exactly linked, stemming directly from the defendant, but the defendant's actions foreseeably could have caused harm. So there are some defenses to negligent torts, and the biggest one is contributory negligence, and that is where the plaintiff's own negligent behavior contributed to the harm that they suffered. So that'll offset some or even all of the defendant's negligence. So if the defendant, runs a yellow and hits your car, but you're really drunk, then that's contributory negligence on your part. There's also a defense of the assumption of risk. So if you knew the danger and you decided to go ahead and take it anyway, you probably can't sue the defendant. So if you go, ziplining and you've signed off that you understand that ziplining can be dangerous and you get hurt while ziplining, you cannot sue the company that provided the ziplining activity. So tort law, in plain English, has somebody done something wrong? Has somebody else been injured because of it? And should the injured person be compensated for the harm? So compensation for harm can be monetary damages and non-monetary damages. So monetary damages can be compensatory damages. Those are designed to place the victim in the position that she would have been in had the injury never occurred. So you basically put a dollar amount on the victim's injuries, and then you try to restore the victim financially, physically, and emotionally. So general damages are going to compensate for monetary loss, and there are special damages that can compensate victims for non-monetary losses, like emotional distress. There are also punitive damages, and those are designed to punish the defendant for wrongdoing. They're also designed to deter future wrongdoing by both the defendant and anybody in a similar situation to the defendant. So if you think about, the Aaron Brockovich case, a lot of these environmental toxic torts, punitive damages are imposed because courts want to make a statement to utilities and other companies that say, hey, you really have to pay attention to this, because if you keep injuring people, you're on notice that you might be on the line for millions and millions of dollars. There are also these non-monetary damages, such as injunctions, mitigation or remediation, and restitution. Now, mitigation and remediation, they do involve money, but the plaintiff isn't getting that money. Instead, the defendant puts money into fixing the problem that it caused. Restitution can be monetary, or it can be the defendant having to make up for slandering you. So the government can also be liable in tort. That could be the U.S. as a whole, a specific agency, the state as a whole, a specific state agency, all the way down. Government employees can be liable when performing their job duties. If they are in their official capacity, then it's basically the same as suing the government. You might sue an individual person, but the government's going to step in and pay all the costs. You can sue people who work for the government in their individual capacity. That is as though you sued them personally without the government involvement. That might happen because you feel that the individual employee is at fault, or for some reason you cannot sue the government, or the government might require that the employee be named. Now, in most cases, the government, as long as its employee was acting appropriately, the government will usually step in and indemnify the government employee. So pay all of the court costs, basically get sued in the place of the employee. Government's got sovereign immunity. This is a legal doctrine that exempts the government as a sovereign from all liability. So generally, throughout history, an individual was not permitted to sue the government. These were usually monarchies. The king was held above the law. You couldn't sue the king. Our federal and state governments have to waive their sovereign immunity in order to be sued. Basically, we need the government's consent for us to be able to sue it. And the federal government has waived a lot of immunity via the Federal Tort Claims Act. But sometimes it'll claw that back in other statutes. State governments also have statutes that waive immunity. Plus, the federal government actually requires that states waive immunity from federal laws, or they give states incentive to do so. This is not always a slam dunk argument. So a lot of times the government thinks, well, I can claim sovereign immunity for anything. But actually, no, just recently, a U.S. District Court ruled that the EPA cannot claim sovereign immunity because there's a statute on point that waives the immunity. So like I said, the federal government has waived a portion of its sovereign immunity via the Federal Tort Claims Act. So we got this because back in July of 1945, there was a lieutenant colonel. He was piloting a B-25 bomber from Boston to New York. He knew that there was almost no visibility, but he attempted to land anyway. He was completely disoriented by the fog, and so rather than landing at LaGuardia Airport, he crashed into the Empire State Building between the 78th and 80th floors. 14 people were killed, including everybody on the bomber and 11 people in the building. Fun fact, elevator operator Betty Lou Oliver was injured because she was in an elevator and its cables got sheared. That elevator fell 75 stories. She survived, and she holds the Guinness World Record for longest survived elevator fall. This particular crash spurred the passage of the Federal Tort Claims Act. Also, there were some retroactive provisions allowing people to sue the government for this specific accident, even though the Federal Tort Claims Act was not in effect at the time of the accident. So the Federal Tort Claims Act gives federal courts jurisdiction over tort claims for damages for injury to persons or property that is caused by negligent or wrongful acts or omissions by a government employee acting in the scope of employment in situations where the U.S. government, if it were a private person, would be liable under tort law. I have an asterisk next to wrongful because wrongful misconduct is never within the scope of employment. So if somebody who works for the government is engaged in wrongful, knowing misconduct, then the Federal Tort Claims Act is not going to apply because they weren't acting within the scope of their employment. Now, like I said, The government has clawed back or reasserted some sovereignty in specific instances, and one of those is in the Stafford Act, which relates to emergency response. And that actually says, forget the Federal Tort Claims Act. We, the federal government, are not going to be liable for exercising or performing discretionary functions or duties when we are carrying out the provisions of the Stafford Act. And again, this is because we don't want our emergency responders to be constantly paralyzed by thinking that they're going to get sued. We want them to go ahead and do their emergency response job. In certain circumstances, there are exceptions to the Federal Tort Claims Act. I will also say that the Federal Tort Claims Act doesn't mean that you can sue the government for as much as you want. You will have a cap on damages. That cap is set by statute. That's the same for all of the state Tort Claims Acts. So if there is an exception, it means the government is not liable for harm. And those exceptions are executive functions, so internal administrative functions, claims arising in foreign nations, the government, you can't sue over that. Discretionary functions that involve planning, policy, and judgment, you cannot sue the government in tort over that. You can sue over operational acts. So if government employees have to carry out a duty in a certain way and they don't, and you're injured, then you can sue. The government is not responsible for employee acts that fall outside the scope of employment. You got to go after the individual as a person. The government is generally not responsible for intentional torts because, like I said, by definition, that's outside the scope of employment. But law enforcement officers and law enforcement agencies are liable for torts of assault, battery, false imprisonment, false arrest, etc. It's non-law enforcement agencies that you cannot sue. There is also the Ferris Doctrine, and the Ferris Doctrine comes to us from Ferris v. United States that actually combined three different cases. And it basically was that Ferris died in a barracks fire. The barracks were known to have a defective hearing unit. That was one of the cases. There was a case of Jefferson, the United States. That was 8 months after abdominal surgery. A soldier was having really bad abdominal pain, and another surgeon discovered and removed a 30-inch by 18-inch towel marked Medical Department, U.S. Army, that had been left in this guy's abdominal cavity. That picture there is not the exact towel that they extracted from Mr. Jefferson, but something very close to it. And in these cases, the federal government has not waived its sovereign immunity, and so it's not liable for injuries to military personnel, even when those injuries result from the negligence of others. It also bars family members of military personnel from filing wrongful death suits. Public duty doctrine. Generally, the government owes a duty to the public as a whole. It does not owe a duty to individual members of the public. And so we cannot sue the government in tort for failure of a public duty to us as individual people. Now, the government may owe a duty of care to an individual if they've got a special relationship. So, for instance, if the government has you in an immigration facility or in a jail or prison, they do have a duty to protect you as an individual from harm. There's a case known as Marin v. United States where Immigration and Naturalization Services released a violent prisoner to do undercover work for them. They knew that this prisoner was obsessed with the victim, but they didn't bother to notify her. They also didn't actually supervise the prisoner, and he escaped and he killed the victim. And the government in that case was liable because it was responsible for releasing the prisoner. It failed to supervise the prisoner on release. It knew of the danger that the prisoner posed to a single person and failed to warn. So there are exceptions to the lack of public duty, and that is the government does owe a personal duty to us as individuals if government officials created the risk that caused our injuries, if they increased the risk that we get injured, if they aggravated an existing injury, if they had some type of way of having custody or control over the person injured, or if there is some other legal duty, either by custom, policy, contract, statute, etc. This is very important in emergency management, because while emergency management agencies don't create the risk that causes injuries, they can, usually through negligence, increase risk of injuries or aggravate existing injuries. So in these cases, those agencies can be liable in tort. So if the government is liable in tort, it's basically as though it were a private individual, except that the government will not pay interest or punitive damages, usually will not pay attorney fees. Now, that's different when it's a civil rights litigation, because then the federal government will pay attorney fees. Litigation takes an enormous toll on agencies. There's the negative publicity and criticism of the agency and its managers, potential for legislative hearings or investigations by Congress. The entire pretrial discovery process for a lawsuit is very onerous. You have to go through, depositions and produce documents and all this. If disciplinary action is pending, then the agency also has to deal with a grievance process internally, and that might serve as a backdrop to the civil litigation. So it's not possible to completely avoid litigation, but agencies can take steps to reduce their liability. So to reduce the risk of litigation, basically you want to be consistent and employ good management. And that means exerting quality control over both operations and personnel. So if you've got a situation where an employee should have been disciplined but wasn't, that actually increases the agency's vulnerability to lawsuits. And while disciplining employees for wrongdoing, that sounds simple, most agencies fail to consistently use proper disciplinary procedures. And that might be because, the employee is personally popular or in good union standing. Maybe the managers are intimidated by the employee, concerns that, if they go after one person, his or her friends will undermine operations, by calling in sick or filing frivolous grievances or some other type of a passive-aggressive action. But if you are properly managing personnel, if you conduct a post-incident evaluation, find out what went wrong, stop it from happening again, I tend to recommend that you speak with everybody involved if there was a problem and you're doing a post-incident evaluation. Also invite, your agency attorneys to attend and give advice. Agencies should quickly and appropriately discipline employees, and that includes management, because failure to discipline really does increase vulnerability to lawsuits. And agencies can proactively seek expert advice if there are particular problems. And then if you document and follow that expert advice, you can show that you're following best practices, that you knew that you were engaging in a potentially dangerous operation, and that you did what you could to mitigate the risk. Okay, so I want to talk about some major environmental cases and some potential avenues for future suits. So we have already discussed the cases that involved Scenic Hudson Preservation Conference and the Defenders of Wildlife. Both of those cases recognize that aesthetic harm can be sufficient for standing, as long as that harm is actual, not hypothetical. There is also a famous case of Sierra Club v. Morton, in which the Sierra Club's case was rejected for lack of standing because the Sierra Club didn't actually allege an injury. This case is actually more important for a dissenting opinion that was written by then Justice William O. Douglas, because in his dissent, he actually asserted that natural resources themselves should have their own standing to sue for their own protection. Now, obviously, a beautiful rainforest isn't going to file a lawsuit. It needs a person to do that. But Justice Douglas's dissent basically said that, people shouldn't have to be injured in order to file suits to protect the environment. So there was Bennett v. Speer, where I talked briefly about this. There was standing found because there was harm. There was Laidlaw, which you read about in our class reading today. So Laidlaw had a Clean Water Act permit to discharge treated water into a river. The permit limited the discharge of pollutants, but Laidlaw just repeatedly discharged additional pollutants into the waterway. It exceeded its permit limits. It also discharged mercury, which is extremely toxic. And in that case, the court held that the plaintiffs, who were residents of the area, had standing to sue the industrial polluter, and a whole bunch of various civil penalties were being pursued there. And standing was proper because those residents said, look, we would have been using this river for recreational purposes if it weren't so polluted, and we didn't use the river, because we didn't want to get mercury poisoning. So initially, a court had found that the case was moot because by the time it got to court, Laidlaw had stopped polluting and it had actually closed that factory. But the Supreme Court said, no, this is not moot because, yeah, it closed this factory, but it still has its license to operate. It can basically just go ahead and do this somewhere else if it is not deterred by, significant fines. And this is where Clean Water Act penalties are intended to deter bad future behavior, not just fix bad present behavior. And the court held here that the injury to the plaintiff came from lessening the recreational and aesthetic value of the area because the area residents knew that Laidlaw was polluting. So that was a big case of standing. There is Massachusetts versus the EPA, which is a case about state government standing. And although Massachusetts gets the spotlight here, this case actually involved, on the plaintiff side, 12 states, 3 different cities, New York, Baltimore, and Washington, D.C., and 14 nonprofit organizations, including Greenpeace, the Sierra Club, and the Union of Concerned Scientists. On the defense side, the EPA gets the spotlight, but it had co-defendants, 10 states, and several groups related to the auto industry. And in this case, the plaintiffs asserted that the EPA's decision not to regulate carbon dioxide and other greenhouse gases violated the terms of the Clean Air Act. The EPA argued that it's got discretion under the Clean Air Act to decide not to regulate. In this case, the Supreme Court found that the plaintiffs did have standing to sue the EPA for damages that related to the EPA's failure to regulate greenhouse gases. And the court noted that while this was argued and treated much like a case between private parties, it was actually a matter of state sovereignty. So it said Massachusetts and these 12 other states, they had a stake in protecting quasi-sovereign interests. So what the court said was that, yes, the state has an interest in protecting its citizens, but independent of that, it also has its own interest as a sovereign in its mountains and its forests and its air. And so this was the case that said, EPA, you do have authority to regulate greenhouse gas emissions if you determine that those emissions endanger the public health. The court also found that the EPA was unjustified in how much it delayed its decision on regulating greenhouse gases. And so basically the court said, look, EPA, you need to consider whether or not these greenhouse gas emissions are contributing to climate change and that climate change is creating injury to the state. After the case of Massachusetts v. EPA, The EPA promulgated regulations designed to control carbon dioxide emissions from light and heavy vehicles, as well as from generators, industrial, and utility sources. So in the case of Utility Air Regulatory Group versus EPA, the court upheld the EPA's authority to regulate greenhouse gas emissions, but the court found that the EPA had exceeded its authority because it adopted different thresholds than set forth in the Clean Air Act, and also because it was applying the Clean Air Act to smaller sources of pollution that are not mentioned in the Act. Now, a lot of environmental cases used to be based on the common law tort of a public nuisance. A nuisance is any human activity or physical condition that is harmful to the health of another person, indecent or offensive to the senses, or interferes with another person's reasonable use and enjoyment of his or her property. So basically, anything that causes offense, annoyance, trouble, or injury. A public nuisance is an act, a condition, or a thing that is illegal because it interferes with the rights of the public generally, rather than with the rights of only a handful of individuals. So for instance, pollution, noise, contagious disease, those are public nuisances. Determining whether an activity or condition rises to the level of a nuisance, it depends on sort of a totality of circumstances test. Relevant factors would include the location and the population, how many people live there, what the prior use of the land was, so historically, what did we use the land for? Did you as a plaintiff move to the location where the alleged nuisance had been ongoing for years, or did the nuisance come to you? Is the nuisance permanent or occasional? How many people is it harming, and what's the degree of harm? So some activities, like roosters in your backyard, might be a nuisance in one location, like the middle of, Manhattan, but not in another, not at a farm in upstate New York. An individual, unless specifically harmed, like you have a special injury, you can't sue for a public nuisance. But a public nuisance can be a criminal offense. It can be remedied by civil or criminal penalties, but a lot of times it takes a public official, like a city attorney, basically to initiate an action over a public nuisance. But if you are being individually harmed by it, then you can sue, because that's the whole concept of due process, is that if you have an injury, the law is supposed to protect you and you should be able to get to the courts. So there have been recently, fairly recently, some more common law public nuisance cases in environmental law. So there used to be all of these common law public nuisance cases. Then it turned out that a lot of times there were statutes that sort of displaced the common law. So for instance, in this ExxonMobil case, it was actually, the appeal was denied by the Supreme Court. In that case, the plaintiffs had sought monetary damages from the energy industry for the destruction of a town in Alaska. The town was destroyed by flooding that was caused by climate change. The Army Corps of Engineers and the GAO estimated that fixing the damage to the town was going to cost somewhere between $95 and $400 million. Well, in this case, the plaintiff sued under federal common law, but the courts held that the Clean Air Act displaces federal common law. So think back to early this semester, I think it was in week 2, when I talked about how a comprehensive scheme of regulation can displace a state's concurrent jurisdiction over something. It can also displace common law. And that's what happened here. There was also American Electric Power Co., AEP, versus Connecticut. It was the first global warming case based on a public nuisance claim, but the court held that corporations can't be sued under the federal common law for like greenhouse gas emissions because the Clean Air Act delegates the management of those emissions to the EPA. So the AEP case limited the possibility of claiming public nuisance in order to fight climate change litigation. There was recently the city of New York sued BP, Chevron, ExxonMobil, Royal Dutch Shell, so all the gas companies, alleging public nuisance, private nuisance, and also for good measure trespass. Basically, New York was alleging that the defendants had known for decades that their fossil fuel products were creating a severe impact on the global climate, and that those fossil fuel producers downplayed the risks to make more money. And New York said, look, we faced more extreme weather, we are severely threatened by any rise in sea levels, and so the city has to take action, meaning spend money, to mitigate the threat of rising sea levels. The court dismissed New York's case because, again, federal common law displaces the state's or the city's state law claims. And basically the court said, look, this can't proceed under state law public nuisance because climate change is an interstate and international problem. And so it can't be resolved under state law. It would have to be brought under the federal common law. And as we've seen in other cases, the Clean Air Act displaces federal common law. City of Oakland also versus BP, Chevron, Exxon, blah, blah, blah. This was a case as to whether or not producers of fossil fuels should pay for anticipated harm that will eventually come from a rise in sea level. This case was pretty interesting because everybody actually agreed that fossil fuels have led to global warming and led to rising sea levels and will continue to do so. So they were all in agreement about that. The issue is whether or not fossil fuel companies are going to have to pay for that. So while it's been made crystal clear that states and cities cannot sue under federal common law just for public nuisance, we are now in some uncharted territory, which is nuisance plus knowledge plus harm. So this is really a reemergence of the public nuisance doctrine, but it's coupled with this knowledge of harm. And plaintiffs in a variety of cases, what they're doing is focusing on the fact that the defendants had notice of a problem. So because of its history of the knowledge of harm caused by fossil fuel emissions and policy decisions to stick with fossil fuels rather than invest in alternative energy sources, states and cities are alleging that the federal government is actually liable for fossil fuel emissions that resulted from its policies and thus the harm caused by those fossil fuel emissions. And because of their knowledge, their history of knowledge of harm about their products, and because they intentionally downplayed that harm, plaintiffs say that the fossil fuel companies themselves are liable for damage. So this isn't just that it's a public nuisance, it's also that both the government and companies have accumulated decades of knowledge that they were causing harm, and they didn't do anything about it. Now, the defendants, both industry and government defendants, argue that the plaintiffs don't have standing because they can't demonstrate that a particular injury, that they have a particular injury caused by climate change, because that is just a very large issue that affects the whole world. Also, the defendants claim that laws like the Clean Air Act preempt the common law, so there's no jurisdiction, or that they failed to exhaust administrative remedies. Sometimes the government will say, well, the Constitution doesn't give us any rights to a stable climate system. So the U.S. courts have not previously recognized a constitutional right to a clean environment or to a stable climate, but that may be changing. So for instance, in a case called Juliana versus United States, which was originally filed in 2015, the plaintiffs were a group of young people led by Kelsey Juliana, plus a group called Earth Guardians, which is an association of young environmentalists, plus Dr. James Hansen, who stated that he was acting as a guardian for future generations. And those plaintiffs alleged that the U.S. government was depriving them of their constitutional rights to life, liberty, and property by promoting fossil fuel development, even as science was showing that fossil fuels were responsible for climate change. So the original lawsuit, the plaintiffs included a lot of declarations, including this one that I've got on the screen from a then 19-year-old named Journey Zephyr from Hawaii, who said, I used to be able to swim at the beach near my house. Now there's no beach left due to sea level rise, and watching the beaches erode away and disappear brings me deep emotional pain. So the federal government tried and failed to have the case dismissed, and it included trying this under the Administrative Procedure Act. So the government cited the APA's requirements of an exhaustion of administrative remedies. But in this case, the district court held that the plaintiffs were seeking review of aggregate action by multiple agencies. And so the APA looks at single agency action and requires that you exhaust your administrative remedies with that single agency. Here, because it was aggregate action in multiple agencies, it falls outside of the APA. So the government's brief that it filed in February of 2019 basically said, hey, look, the plaintiffs have no fundamental constitutional right to a stable climate system. Climate change is a global issue, so the plaintiffs are not suffering from a legally actionable injury. Instead, they've kind of got generalized grievances. And because climate change is global, even if the plaintiffs did have a legally actionable injury, the plaintiffs can't link that injury to any specific federal government agency action. So in this case, the district court for the District of Oregon, the judge ruled that access to a clean environment is indeed a fundamental right, but the government naturally appealed. And so this went to the Ninth Circuit Court of Appeals, which had to examine several questions. Are government agencies responsible for some or all of the harm caused by climate change? Can the plaintiffs challenge agency climate change policies in court? And if so, can the courts force the government to change its policies without violating the separation of powers? So that is, are the courts allowed to tell the EPA that it's got to make different policy decisions? So the Ninth Circuit reversed the district court's holding, and it wound up dismissing the case for lack of standing. The Ninth Circuit said, it's beyond the power of the court to order, design, supervise, or implement the plan that the plaintiffs were requesting. And the Ninth Circuit noted that any type of effective plan would require a whole host of complex policy decisions, and those types of decisions are entrusted, as the court said, for better or worse, to the wisdom and discretion of the executive and legislative branches, so not the judicial branch. Now, the Ninth Circuit was sitting as a panel of 3 judges when it handed down this ruling. So the plaintiffs have already stated that they plan to appeal to the Ninth Circuit sitting en banc, meaning that the full panel of judges, not just 3, will hear the case. If the Ninth Circuit declines to hear the case en banc, the plaintiffs can appeal to the Supreme Court. If the Ninth Circuit agrees and does hear the case en banc, then the losing party will be able to appeal to the Supreme Court. So this one might be going on for a while. There is also this Rhode Island case against Chevron, BP, ExxonMobil, Shell. It is the first climate change lawsuit filed by a state that was brought under an area of law that allows Rhode Island to prevent public nuisances, specifically those that pollute public property. So federal courts have rejected these claims in previous lawsuits, but the state courts haven't done so. So this is actually, Rhode Island is making this allegation under state law, not federal law. And Rhode Island says, look, we're facing injury and costs related to excessive heat, rising sea level, lots of flooding. Climate change is already impacting state-owned and operated facilities throughout Rhode Island, and these facilities are critical for operations, utilities, and risk management. And here the focus is not on climate change as a whole, but on specific bad actions of the defendants, such as false statements and campaigns of deception to try to really downplay the whole issue of climate change and how fossil fuels contribute to it. And this is very similar to the approach that was taken when state attorneys general sued Big Tobacco. And it's what states are now considering this route to deal with the opioid epidemic. So it's not a big, huge epidemic as a whole that they're going after. It's actually going after the bad actions of the defendant. And then we've got the case just recently filed of Pacific Coast Federation of Fishermen's Associations versus Chevron, BP, blah, blah, blah. And this is the first suit by food producers against the fossil fuel industry for allegedly harming the environment. And like the Rhode Island case, here the plaintiffs are alleging a nuisance, also strict liability for failure to warn the public about what was happening. And here the plaintiffs are alleging that the fossil fuel industry concealed from the public all of this knowledge that burning fossil fuels could have catastrophic impacts. The plaintiffs say the industry knowingly subjected the whole planet and future generations to these dire consequences of their actions just because they wanted to make a lot more money, and the industry is thus at direct fault and has to be held accountable for recent damages to the West Coast's crab fishery and other fisheries that relate to global warming, acid outbreaks, basically other problems that the plaintiffs say are a direct and proximate result of the defendant's actions. So this one is really interesting because the state actually provided a relief package to these fishermen because there have been several fishery disasters, including massive failures in salmon fishing in Northern California. And the plaintiffs in this case are saying, hey, we appreciate the help from the taxpayers, but the general public shouldn't be the one on the hook for damages resulting from warming oceans. The financial harm should be covered by those who are perpetrating it, who have spent decades underplaying it, and have done all of this because they're just wanting to make more and more money. So this is another one that'll be interesting to watch as it makes its way through the court system. And it does appear that at least some of these cases will move forward in state courts. In October of 2019, the U.S. Supreme Court declined to halt litigation targeting fossil fuel companies for their role in climate change. So the court actually denied applications from BP, Chevron, Suncor Energy, ExxonMobil, and other companies that were seeking to halt these proceedings with cities and states, including the city of Baltimore, state of Rhode Island, and various Colorado municipalities. So in line with what we just discussed, these state and local governments filed suit in various state courts, not federal courts, claiming that the fossil fuel industry created a public nuisance by producing and selling products that harm the Earth's climate. Now, the companies argued that it's federal courts that should decide these claims because they are very broad, and the breadth of the climate change problem requires a federal response, not a state response. Now, that argument does have a lot of merit. We don't necessarily want a patchwork response to climate change, but forcing litigation into the federal courts would be very advantageous for the defendants because, as we discussed, Supreme Court precedent currently blocks federal common law claims against greenhouse gas polluters. However, all of the federal courts that heard from these fossil fuel companies who were trying to get out of state court wound up sending those cases back to their respective state courts. So at that point, the companies petitioned the Supreme Court to block those state-level actions, but the Supreme Court said no. So now we wait and see. It's going to be pretty fascinating to watch these cases develop in the various state courts. We can see if there's any consistency in state court responses. Okay, thank you. I know this was a really long lecture this week, so thank you for sitting through it. This week on the discussion board, we've got D6, a civil action. I do want this to be a free-flowing discussion, so I really want you to share your thoughts and pose your own questions to your classmates, but just in case, I have included some potential questions to kind of get the ball rolling. Looking forward, your second memo, which is going to be about the Stafford Act, that's going to be due in week 13. The syllabus in PDF format currently has it due in week 12, but instead what I'm going to do is open a discussion board so that you can work collaboratively throughout weeks 12 and 13 before you have to submit that memo. All right, thank you again for listening. Have a great week. I will see you on the discussion boards.